Concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices in Montclair, New Jersey. Montclair, Nutley, New Jersey. Today is Tuesday, February 5th, 2019. I am recording this in New Jersey, so everything I talk about relates to New Jersey law. If you're watching this anytime after 2019, especially at least February 5th, anytime shortly after, or in another state, always need to check if what I say here applies. I'm doing today my how-to series. I do videos every day. I do a daily tip where I take a small piece of advice and give you a short tip. Then I do a weekly series on a broader topic where I try to give you just kind of what I consider like a medium piece of advice towards a large topic. Today I'm going to be talking about how to defend a motion for temporary support, also called pendente lite support. That is when somebody files in the beginning of a divorce to get support paid throughout the divorce, not related to alimony afterwards. Well, in New Jersey, it's kind of related to alimony afterwards, but for the purpose of today, it's not going to be discussed. I'm also going to be making certain assumptions when I speak of how to prepare, and that's going to be that the person filing the motion either is not working or is earning very little and is asking for either a substantial amount or at least to have a lot of the household bills and car-related expenses covered, as well as some temporary support and maybe child support. So if your situation is different or the support requested is different, this may not apply as equally to you. But moving on to how to prepare. So there's a few things you need to do if you're on the receiving end of a motion for support. The first is to make sure that you complete a case information statement. The case information statement is a very long, tedious document that you need to file in a divorce case when there's financial issues or equitable distribution. It's very tedious. It's asking you from everything from how much you pay in income tax each year to the value of your assets to what you spend on hair care in a given month. Now, I tell my clients this document needs to be accurate, but not exact. It's a summary document. So they're not expecting you to know exactly how much you spent on your hair care last month, but they want a basic average. And you want to make sure that your numbers are correct. You want to do what you can to attach bills that evidence those payments and those expenses to your case information statement. You may want to also attach bank statements, credit card statements. You can attach your mortgage statement. You're allowed to attach as much as you want to support your case information statement and the numbers that you put into it. And that's crucial because this case information statement is probably the most important document that you're going to file in your divorce case. And if you're defending a motion for temporary support, it's certainly the most important document at that moment. So you got to make sure that your numbers are correct and that they add up properly. You also want to make sure that the other person's case information statement is accurate. And this is crucial also because, again, it's a summary document, so it's going to be usually off. Person who's seeking a substantial amount of support will often, whether it's intentionally or unintentionally, inflate their monthly expenses and their needs, thinking that that will in return inflate the amount of money they received. And if you're not careful, it can. So you want to be able to digest their case information statement very thoroughly, one, by pointing out how it's different from your case information statement. And if you do your case information statement and attach the documents I'm saying to attach, you can evidence it with the actual submission and the documents. You also want to look to the common sense approach of that. And does it make sense, first of all, that you would have lived a certain lifestyle like this? Do the numbers add up in a way that makes fiscal sense? For instance, do the total of expenses, household expenses, equal or exceed the net take-home income? More often than not, it will. Partly because it's hard to estimate the exact numbers, partly because many people live beyond their means and use credit cards, and other parts because people inflate their numbers. But you need to know which one it is. If it's credit cards, the courts may still consider you to use or have to use credit cards to support that. But you got to know going into it which one it is. After you get your case information statement information together, you're going to have to file a response. Now, inside of that, you can file and should file a cross motion, a separate relief document to the court asking for certain things that you want the court to enter. Now, you may have many things that you want, but relating specifically to the relief in temporary support, you want to ask that, first of all, the court not accept an argument about status quo. Chances are the person who files a motion is going to argue status quo, this is our status quo, the court has to keep the status quo. It's not the status quo. People think it, judges say it, the statute doesn't. And most people don't realize that. The statute talks about support, it doesn't talk about status quo. So the first thing you need to do is point that out so that the court's not trying to make you measure up to what you did in the past. Because most of the time you can't. You're in a divorce, you may have a separate household, things are going to change. The status quo is just not feasible anymore. Second is, you want to ask the court, when they order the relief, not to order you to pay the bills, but to order you to give a fixed sum of money and let that other person pay their bills. The reason is, first of all, you don't want to just be an open checkbook. You don't want to just pay if they let your bill comes out in 1 month at $300 and 1 month at $600, they have to pay either one. You want the court to set a dollar amount so that the other person is forced to budget and be responsible for him or herself and to be their own bookkeeper. You don't want to be writing checks for them either. It's not fair. You should give X amount of dollars and they should be responsible for it. You also want to ask that they review temporary support motion in 3 or 6 months. Now, this is often hard to get, but you want to try for it and you want to press as much as you can, depending on the facts of your case and what I'm going to talk about in a second, will determine whether you get it or not. The problem with temporary support is it's done in the beginning of a case with very little information. So the courts could possibly make the wrong decision on either side, whether it's you're paying or you're receiving. And it's usually not going to be reviewed at all during the whole divorce case. So if you're subject to an excessive support motion, you're not likely to be able to change that throughout the course of the case. Now, judges will tell you, and they'll quote a case called Malamo versus Malamo, and they'll say, well, you can retroactively apply or retroactively modify it at the end of the case. But that doesn't help anybody. If you have to pay support the entire time through your divorce, getting relief at the end doesn't help. You've paid the money out. If you have it, you're in contempt. If you have, you're not likely to get it back. So you want to do what you can to make sure it's going to be reviewed at a point in the near future, because it's not based on income that's accurate or information that's complete. And lastly, and sort of related to this, you want to ask that the other person be required to search for a job and to report back to the court with proofs that he or she has been searching. You don't want somebody to get a substantial or a comfortable support award and decide to just sit around because the divorce will take 12 months and they're going to keep their money running. You want to make an affirmative obligation that they have to be searching for a job and that they have to submit that proof to the court, which brings us back to the 3-month review. That will give more credence to the court ordering that if there is a person who's not employed or underemployed. Nobody is allowed to just sit around and not earn anything. But if you don't ask for these specific things inside of your cross motion, the court won't give it to you and they won't review it at all. And you'll be stuck with possibly a very long, arduous support motion. And the problem with support motions overall is they will set the tone, or it will set the tone for your entire divorce litigation. If the support is set too high and you're struggling for money, you're pressured to settle your case more quickly and less to your advantage. If you're a recipient of a support award and it's too low, similarly, you're forced to resolve it for financial reasons also. We hope the court will do the proper balance and get the right numbers, but it's hard to say, and it's usually not the case because, again, it's early in the case and not with accurate information. So because these are so important, I hope this information helps you. I may one time do a larger webinar video on this issue because I think it is very significant. But until then, if this information helped you, I'd certainly appreciate it if you would like the video and share it with others so that they get to see it. And with that, I'm going to sign off, and I should be on tomorrow. I just haven't scheduled the time yet, but probably 4 o'clock like normally. Oh, actually, maybe not because I'm supposed to be in court tomorrow. But if I'm not in court tomorrow, I'll be on at 4 o'clock. Thanks.